conviviality of this symposium, where lots of friends and then people like me, fellow travelers, are here. I'm Catherine Fisk. I teach here at UCI Law School. I teach labor and employment law, among other things, in the legal profession, and but have written on low-wage work, and in particular, some on organizing among immigrant workers in Southern California. And so it's an enormous pleasure for me to have this conference here. I don't get to go to immigration conferences because there's just not enough time in the world, but I try and read everything that I can, and so it's just such a treat to have all of you here. And I am also the faculty advisor to the Fleshlight UC Irvine Law Review. And let me say, on behalf of the students involved in the Law Review, some of whom are in the room, how grateful we are to those of you who are writing papers for inclusion in this volume. You do us a great honor by sharing your ideas in print with us, and I'm hopeful that our students will do your work in honor by doing a great job with it. And if not, let me know and I'll crack the whip. I'm not worried about that. This is the panel on immigration and work. And just by way of introduction, all three of today's panelists focus on the core tension, a puzzle to go with Stephen's theme, underlying immigration, or the intersection of immigration and labor law. As we all know, as conventionally said, most people migrate to the United States to work, always have, probably always will. Work is, as everyone says, the magnet. But as we know, immigration law makes work illegal for many. And that, as Kathleen will talk about, and as many have, enables employers to exploit exploit immigrant workers, which of course creates an incentive to hire them and gives them a competitive advantage, in theory, and gives employers who want to engage in that kind of exploitation a competitive advantage. But that competitive advantage is thought to subvert both the law and policy of immigration law and the law and policy of labor and employment law. And so this panel, three of the wonderful papers on this panel, address that core tension or puzzle and try to come to grips with the concepts about the illegality of work and the illegality of exploitation. We're going to go in alphabetical order, beginning with Jennifer Gordon, a professor at Fordham Law School, where she has been on the faculty teaching immigration and labor, among other courses, for a number of years. And as probably you all know, prior to entering law teaching, she wrote a really terrific book that I have read and assigned called Suburban Sweatshops, and was the founding executive director of the Workplace Project, a really path-breaking worker center on Long Island that has been a model for many other worker centers and by itself has generated all sorts of interesting scholarly inquiry. Her paper will offer some critical insight into the arguments that immigrant workers' rights advocates make about why, other than basic human decency, it is important to protect the labor rights of all workers, including unauthorized migrants. And so that she's going to take on the challenge of coming up with an answer to the conventional question of, do you think that undocumented workers actually have a right to work in the United States that should be protected? How should we address that? Next, in alphabetical order, Kathleen Kim, an associate professor at my old employer, Loyola Law School of Los Angeles, where she teaches torts and immigration law, really a pioneer in both activism and legal scholarship on human trafficking, where she did civil litigation on behalf of human trafficking survivors for the Lawyers Committee for Civil Rights in San Francisco, and actually is a gubernatorial appointee to the California Alliance to Combat Trafficking and Slavery coordinated by the California Attorney General's Office, so that wonderful kind of intersection between theory and practice. Her paper is going to focus on how the unauthorized status of migrant workers makes them uniquely susceptible to coercion. It's going to take on some of the 13th Amendment conceptual work focusing on the question of coerced labor. And then last but not least, Juliet Stubbs, a professor at Lewis and Clark Law School, where she teaches immigration law, employment discrimination, and civil procedure. Previously served as a trial attorney, a senior trial attorney at the Civil Rights Division of the United States Department of Justice, where she litigated employment discrimination claims and claims on behalf of immigrants and U.S. citizens of color. She's going to examine the contemporary debate over whether to universalize the E-Verify system in the context of longstanding arguments about the role of government in regulating eligibility for employment and formation of the employment relationship. The Immigration Reform and Control Act, as we all know, like lots of laws, some that we consider morally acceptable, some that we consider morally extremely objectionable, defines who is eligible and who is not to work by drawing a circle around some workers, which leaves some in and excludes others, and that creates a whole lot of conceptual and practical problems that she will talk about. So let's begin.
So I took the theme of this symposium as an invitation to look more closely at what I felt were some of the tensions and puzzles in my own work and in the things that I've been saying for some 25 years now about the intersection of immigration and work. This sort of, the particular knot of puzzles I want to talk about today started to feel thorny to me as I sensed increasing dissonance between two things that appear in almost every article, book, paper that I write. And in fact, originally I would have said the challenge was just saying the same thing differently. And those two things are, A, that if you look at what economists say, in fact, immigrants and even low-wage and undocumented immigrants do not have any significant impact on native low-wage workers in the United States, if you look at the United States overall. Another version of this, often used in the public debate, is immigrants take jobs that Americans won't do, right? So that's one way that I and other advocates and scholars respond to the fear, a common fear, also a trumped-up fear, that if we let in more immigrants, it's going to hurt native workers. And the other common way that we respond is saying that even if you don't have any, you, the public, don't have any connection to or concern for undocumented workers, you should support the enforcement of their labor rights, because only when everybody's labor rights are enforced are anybody's labor rights real, and that we have to make sure that undocumented workers have all the rights that native workers do, or they're going to be more desirable to unscrupulous employers, right? Those are the two things. I've said them a lot. Many people in this room have said them a lot. I want to start off by exploring what I think is just a really obvious tension between those two. Obvious, but also, I think, resolvable. And then go on to what I think are some more thorny questions that are under the surface. And I should say, in starting, it's not that I think that all the tensions and contradictions are on my side, right? You look at what many people who argue that immigrants are competition or immigrants are going to hurt our workers, and there's inconsistencies all over the place, including that many of the people who profess most concern for our workers in that context vote against minimum wage increases, health and safety increases, increase in any kind of workplace protection. So not a free pass there, but this, for me, is an exercise in cleaning my own house. So let me first lay out the core arguments on the economic and workers' rights front, right? Seen overall, if you look nationally, most economists now agree, the vast majority of economists now agree, that immigration as a whole has either a neutral or small net positive impact on the national economy and on the workforce overall. And I have to say that when you say that, that strikes most casual and not so casual observers as preposterous, right? Most people have an image of the labor market as a fixed pool of jobs. You have more people coming in and that increases competition. So it must drive wages down and must put people out of work. And the economist's general response to that is, first, that immigrants are not what they call perfect substitutes for natives. That is, immigrants have different assets, and they don't have the language skills or cultural familiarity of natives, so they're going to get the jobs that require limited literacy and limited interaction with the public or other workers outside their language group, and native workers are going to get the jobs that require reading and writing and job-related training in the United States, and so on. It's not, economists say, that immigrants compete with nobody for jobs. They do compete, but who they compete with are other recent immigrants. That's where you can see an impact, not on native workers. The second thing economists say is, in fact, despite the common intuition, the pool of jobs is not static, it's not fixed. And immigrants are also consumers, so they increase the demand for goods and services, therefore creating more jobs. And employers change how they structure their work in the face of a large supply of immigrant workers. They choose more labor-intensive methods rather than capital-intensive methods. And that also increases the number of jobs and increases the opportunities for native workers to move into supervisory or other positions. So that's the economic argument. The workers' rights argument, basically what we say as workers' rights advocates is, first, immigrants are already covered by the majority of workplace laws. They're covered under the Fair Labor Standards Act for minimum wage and overtime. They're covered under the Occupational Safety and Health Act for a safe and healthy workplace. In most, in most circuits, they're covered under anti-discrimination law. In most states, covered under workers' comp law. And even the worst and most prominent decision in this field, the Hoffman Plastics decision that says there are effectively no remedies for a set of undocumented workers under labor law, that is labor and organizing law, still affirms that they are employees within the definition of the Act. And what we say is what we really need to focus on is enforcement and making these rights truly available to the workers as opposed to just available on paper. As with the economic argument, this is met with some mixture of concern and disbelief by most casual observers of the situation. People say if undocumented workers are illegal, how do they have rights? If they're not supposed to be hired by employers, how can they work at all? How can they make a claim? And people also express a sense of inequity. Isn't offering rights to the undocumented some kind of incentive to break the law? Isn't it a reward for wrongdoing and so on? That argument was most powerfully expressed and most publicly directly to me when I was testifying before Congress, arguing that employer sanctions should be revealed. And Representative Maxine Waters, a Democrat from California, said to me, "Let me tell you where you must examine your argument. You must examine the argument that says somebody who's here illegally in the first place has a right to go and challenge anybody about the conditions of the workplace. That argument won't fly in this public policy making we have to do," right? And at which point my heart, which is already pretty much as low in my physical body, just went completely through the floor, because if this is what Maxine Waters was saying, then we were really and truly sunk. Now, from the perspective of most immigrant worker advocates, the primary reason to enforce workplace rights for undocumented workers is that they are human beings, they make contributions to this country and to workplaces all over the country, and that the US government covertly and sometimes overtly invites them to come in, and therefore the government is responsible for the result. But that's not the principal rhetorical argument we offer to the public. Instead, we say, if you don't protect the undocumented, they will be cheaper than other workers, and they'll be less likely to complain, and so the bad employers will hire them over other native workers. And the core assumption, and here we come to the tension, the core assumption underlying this is that the undocumented and legally authorized workers are competing with each other for jobs, and this is much rarely explicitly stated, but I do believe it underlies a lot of public statements, that immigrants will return home when they can't find work anymore. That is, that this sort of labor law enforcement is in a way a more humane or an alternative to a direct deportation strategy. So just to deal up front with what is the most obvious tension, if immigrants don't have a negative impact on natives' wages and working conditions, and if immigrants take jobs that native workers won't do, then they're not competing with native workers for jobs. And so other than human dignity, human decency, human kindness, why should native workers care if those workers' rights are enforced? They're not actually in the same labor market. It's not going to matter. And I think that tension is actually resolvable to a large degree by a more nuanced look at what economists really are saying. Everybody agrees, I think without exception in the world of economists, that high-wage workers, high-skilled workers are an asset to the country that receives them. That's a good deal for the country they're coming into. There is more debate at the low-wage, low-skill end. Nonetheless, most conclude that it's foreign-born, other recent immigrant workers most likely to be hurt. But there are some who argue that the impact does fall in a meaningful way on native high school dropouts and those with minimal job experience and training. That's a small and shrinking group of people. It's down, for example, by 3 million people over the past decade. But African Americans and other workers of color are overrepresented in that pool. And even those who have argued most vociferously for the harm to native workers, George Borjas comes to mind, still report a fairly small effect. He says the increase in immigration over 11 years of very high immigration resulted in a 3.6% decrease in the wages of high school dropouts in the United States. Now, that's a small but also real decrease in wages for somebody earning, say, $20,000 a year. That's $720 a year less. And I think that effect, the real effect, gets magnified by the media's obsession with this idea of conflict between African Americans and immigrants, an obsession that persists even in the face of polls consistently showing that African Americans are more favorable toward immigration than white Americans. So, in one sense, this surface tension, we could resolve the surface tension by doing a better job of, or clearer job of saying what we're saying. We could say immigrants are largely beneficial to the economy and to U.S. workers overall, but to the extent they have an impact, it's on other low-wage workers, both foreign-born and high school dropout. And in that sense, the weight falls on the most vulnerable native workers, and African Americans in particular, who are overrepresented in that pool and historically disenfranchised, and that merits extra concern from us as advocates. And so at the very low wage end, I think it's consistent to argue that focusing on protecting workplace rights for everybody, decent work for all, as our mantra, is not logically inconsistent. I'm also aware, though, that that is sort of an easy, perhaps a too easy place to rest, and masks a lot of other things going on underneath the surface that I just want to run through, my 4 biggest keep me up at night concerns, and then I look forward to discussing with you. So these are concerns really about that position that I just stated as the tension resolving position. The first thing I would say is I worry that that position overstates the impact of immigrants on what's happened to African Americans in work, and thus falsely reinforces the story of conflict. African Americans have the highest rate of unemployment of any racial or ethnic group in the United States, and immigration into low-skilled jobs may account for a small part of that rate. And yet other causes dwarf competition with newcomers. Among those other causes, the sharp decline in unionized industrial jobs that gave were opportunities for decent work for many black workers in the United States and lifted many into the middle class, and for which they fought over a long time. The increase in privatization of government jobs, public service previously having been another unionized stalwart opportunity for African American workers who were often denied access to decent public employment. Ongoing discrimination by employers against African Americans in favor of white and other favored racial groups, and the criminalization of young black men and large rates of high school dropout among African American students are two other key factors. And if we're going to acknowledge an impact of immigrants on African Americans, I think we have to also give equal play to these other much more important factors. So that's one, and that's my thought about it. The second issue is that I worry about the jobs Americans won't do narrative. Right? This is a trope that gets pulled out all over the place, and I do believe there are indeed some jobs Americans may never want to do again. Americans, that is, people who have a choice in our labor market, defining Americans that way. Agriculture, right? Farm work is hot, it's hard, it's poorly compensated, and it has demeaning associations in many people's minds. And domestic work may be in a similar category, although there are still plenty of native farm workers and domestic workers. But the resistance to those things is not inherent in the job. There's no natural work Americans won't do. It's shaped by the wages on offer. It's shaped by the cultural perceptions about the work, and these things can change over time. If you raise wages for workers in residential construction, for hotel staff, for janitors, for health aides, home health aides, native workers may well be willing to apply for them. And with immigrants flooding those labor markets, demanding higher wages is much harder to do. And the question is how we talk about this honestly, as opposed to just bringing out the phrase. Now I want to get to what I think is really the heart of my concern, which is a focus on labor rights, the one that I've advocated and many of us have as well, really likely to shift employer preferences in the absence of meaningful penalties for employers' immigration law violations? To the extent that we offer this, we often, and I speak for myself, have sort of pushed it to the side as a realistic possibility. You know, would this really result in large turnover of jobs to immigrants? And, you know, given how other things are enforced, not likely, and I don't think we've taken the question seriously enough. I don't know what the evidence is to support it. I'm not saying it's not out there. I'm saying I don't know what it is. I have stories to tell that are disturbing to me, but I have them to tell about how employer sanctions crackdowns have changed hiring in labor markets. I don't have those stories, and I welcome them, about how labor law, workplace rights enforcement has actually changed hiring patterns. And I think that's because wages, minimum wages and minimum workplace conditions are set very low in the United States. The majority of employers already comply with them. And there are other reasons that employers prefer undocumented workers: control, subservience, and the lack of ability to argue back in English being high among them. And I think we also need to acknowledge that immigrant workers, new immigrants, do face a different picture than native workers. They come with crushing debt. Work is their only opportunity to pay back that debt. They see their work here, at least in the beginning, as short-term. The money they earn goes further back home. And so, to the extent that they have that willing is understood to be not fully willing in the sense that we wish it was, they may be willing to do more work for less money, and labor law enforcement is not going to change that. So the last concern is the question, if labor law alone is not actually going to create any change, is there any such thing as a good employer sanctions policy? Now, many in this room, including Bill Hain and Mike Wishney and myself, have been arguing that the answer is no. And we've been arguing this for the 25 years since employer sanctions is passed. We've been saying employer sanctions gives union or employers a tool to undercut union organizing and workers who demand their rights, and this should be repealed. And this was particularly evident, I think, self-evident when combined with the Bush government's brutal policy of workplace raids. And the raids, frankly, continue under Obama, although we're calling them silent raids because they result in workers being fired rather than deported. Our continued opposition to silent raids and to the firing of undocumented workers puts us in the position of having to answer, do you believe that the undocumented have a right to work in the United States that should be protected? Now, obviously, part of the answer to that is legalization, right? That there's all those arguments have been played out in other panels, and there's more to say. But I think what we have the hardest time answering, what we need to spend more time thinking about, is what are we calling for by way of future flow policy? Policy for those who are going to keep coming into the United States, whether we have a law that admits them or not. Now, maybe we should call for open borders, right? Kevin Johnson has made strong arguments for that, as have others in this room and elsewhere. And maybe the reasons are, as Phil Haynes with Bacon recently argued, the institutionalized racism that U.S. immigration law has never been able to escape, the role of the United States in creating the conditions that lead people to migrate, and so on. But if we're going to argue and say our future policy should be open borders, I worry deeply about the impact of that on the most disadvantaged workers in the United States. Right? I don't think we can just walk away from that question. And if we don't want to call for open borders, but we do believe that given global inequality, significant ongoing low-wage migration is going to keep happening, and we're concerned about the impact, and we don't believe that labor law enforcement is seriously going to change that dynamic, and we don't think sanctions is the right approach, what is our position about how to manage immigrants, low-wage immigrants still to come in the United States? I asked the question, having already spent a fair amount of time working on one possible answer, a proposal for transnational labor citizenship that would try and shift the incentives in immigration law to create more solidarity and more reasons for immigrants and possibility for immigrants to be able to enforce their rights while they're here. But that is, in some measure, a fantasy picture as opposed to something that's immediately implementable. And we need more proposals, and I think we need more honest conversation about these questions. And so I welcome that. Thanks.
Thanks so much to everyone at UCI, as well as you, for inviting me to be here and organizing such an amazing conference. I'm humbled, actually, to be here, not only by my co-panelists, but everyone else participating in the events for today. And thank you, Catherine, for a very comprehensive introduction. And I think it's particularly suiting that Jennifer did start us off, because she very succinctly outlined the tensions that do exist within the debate around undocumented workers, as well as legalization. I like that tie into legalization at the end of your comments. And so I hope to make some comments about legalization at the end of my talk as well, and how my particular work, which focuses on human trafficking, might provide a lens to make steps towards that goal of legalization, though a little bit differently. So as Catherine already mentioned, my practical experience and my scholarship center on the issue of human trafficking, and as such, it's a part of a field of scholarship at the intersection of immigration and workplace rights. 90% of human trafficking victims are immigrant workers, and I take a distinctly immigrant workplace rights approach to the issue of human trafficking, which I believe is grounded in the 13th Amendment protection of free labor. There are other approaches to human trafficking, including women's rights, international human rights, but mine is one of immigrant workplace rights. So naturally, it makes sense that the particular project that I'm going to be discussing today, which is tentatively titled Incoercible, as suggested by Jennifer and Stephen late last spring when I presented a work on the coercion of trafficked workers, so I thank them for that. It's only tentatively titled incoercible, though I've gotten some pushback on that, and it might change to beyond coercion. But that particular project is part of a larger project that began several years ago when I participated in a 13th Amendment symposium among labor theorists such as James Grace Pope, Leo Vandervelde, Maria Ontiveros, and Rebecca Zietlow, who viewed the 13th Amendment as an anti-subordination principle and as a free labor principle. And in that symposium piece that I contributed to that 13th Amendment symposium, I did discuss human trafficking as yet another form, modern form of unfree labor, whose characteristics remain, at the time at least, largely misunderstood. And I also identified a conflicted question within 13th Amendment jurisprudence, and at the time, still insufficiently answered in human trafficking law, namely, what kind of coercion could amount to a violation of involuntary servitude. So that kind of question necessarily raised more profound questions of the nature of free will, requiring a very in-depth and theoretical and philosophical analysis into the normative structure of coercion. And at the time, I was way too green and extremely daunted by the prospect of pursuing such a challenge. So it took me several years, but recently I did answer those questions in an article called The Coercion of Trafficked Workers. And so that just came out, and that is really the springboard for the project that I'm working on today. So just by way of background, however, that particular article utilized the basic framework of the first piece, but significantly developed the doctrinal analysis undertaken in that first project, and also drew from modern philosophy to define the prevailing ontological and normative framework for coercion previous to the passage of the Trafficking Victims Protection Act, which was passed in 2000 to address protections and criminal provisions against human trafficking, and then also identified a new ontological and normative framework for coercion, only recently developed as a result of new advancements under the Trafficking Victims Protection Act. So what are those frameworks, pre-TVPA and post-TVPA? Well, pre-TVPA, I believe there was a dominant theory of coercion, what I call the known reasonable alternative theory, and what modern philosophers have called the moral baseline approach to coercion. And as applied in the contemporary involuntary labor context, in order to establish a violation of involuntary servitude, that theory, the no reasonable alternative theory, would require an employer to leave a worker with no reasonable alternative but to perform the labor. So that requirement involves a specific threat, a specific and identifiable threat by an employer, which must be determined to be morally objectionable. And therefore, that threat would have to be so severe that a worker is in fact left with no choice but to comply with the employer's demands. In other words, the threatened alternative by any moral objective standard must be so egregious that it would be unreasonable for a worker to choose it over remaining in forced labor. Until Congress passed the Trafficking Victims Protection Act in 2000, the judicially recognized threatened alternatives that could amount to involuntary servitude comprised of only threats of physical violence or threats of legal penalty for failure to work. That follows from a well-recognized Supreme Court case called U.S. v. Kosminski in 1988. So that structure, I believe, makes intuitive sense because it can be widely agreed upon that such threats are morally objectionable, while non-physical and non-violent threats, such as a threat to not send money home to a worker's family members in that immigrant worker's country of origin, might not clearly be morally objectionable. And therefore, courts and the U.S. Supreme Court in that case refused to recognize those kinds of non-physical threats as a violation of involuntary servitude. Yet the persistence of cases involving immigrant labor and what appeared to be forced labor conditions without threats of physical or legal constraint encouraged the Department of Justice to make an appeal to Congress to expand laws against involuntary servitude. At the same time, feminists, labor rights advocates, and immigrants' rights groups were also lobbying for new legislation to specifically combat human trafficking. Then, in 2000, the Trafficking Victims Protection Act was passed, explicitly overturning the previous more restrictive laws regarding involuntary servitude and officially broadened the coercive means sufficient to find for forced labor violation, specifically allowing psychological coercion in addition to physical and legal coercion to effectuate a violation of forced labor. And with that, importantly, the Trafficking Victims Protection Act also provides immigration relief for individuals that were found to be trafficked. And therefore, coercion, the legal sufficiency of coercion, became a fundamental inquiry in obtaining immigration relief for a broad category of exploited immigrant workers. However, the Trafficking Victims Protection Act, as initially promulgated, failed to define psychological coercion, stating merely that it was non-physical and non-violent, and due to the ambiguity of coercion under the first promulgation of the Act, I proposed in this previous article that it lacked clarity and therefore allowed for the persistence of the dominant no reasonable alternative framework for determining cases of involuntary servitude. This overall resulted in the under-enforcement of non-physically coerced human trafficking violations, and my survey of trafficking prosecution since the enactment of the Trafficking Victims Protection Act shows 75% evidencing overt or threatened physical force, while at the same time anecdotal testimony advocates in the field attest to the Department of Homeland Security's and law enforcement's general reluctance to recognize certain cases of trafficking in the absence of physical harm. In 2008, the Trafficking Victims Protection Act brought greater specificity to the definition of coercion, clarifying that direct and indirect threats of financial, reputational, and psychological harm for failure to work could actually amount to forced labor. And several court opinions also holistically applied this definition of trafficking, bringing further clarity to coercion. From that analysis, I extrapolated what I believe to be a new framework for coercion, which I call situational. And this is derived from the statutory language as well as these court opinions. And the structure of situational coercion, what it is that it requires the evaluator to evaluate all the surrounding circumstances of the alleged forced labor scenario, paying close attention to power inequalities and the workers' individual characteristics that may render them vulnerable to exploitation, and ask whether the employer deliberately took advantage of a worker's vulnerability to obtain labor at an exploited price. And this, in my opinion, better matches the sociological realities of trafficking, which frequently involve non-overt pressures to work marked by these severe power imbalances between the worker and the employer. So the operationalization of this framework requires that the adjudicator, again, takes a look at all the surrounding circumstances with close attention to workers' vulnerabilities to determine if that employer indeed took advantage of the worker to keep them in exploitive working conditions. So under this framework, immigrant workers who are threatened with eviction from their employer-provided housing when they complain about their working conditions could actually make a claim for forced labor and therefore obtain immigration relief under the TVPA, whereas under the no reasonable alternative framework, that threat is not clearly morally objectionable because it still leaves the worker with a choice to simply leave, find housing, and find another job elsewhere. And in fact, it seems legitimate that an employer who provides housing to the worker can take back the housing if the worker complains and wants to leave the work situation. However, if all the circumstances of the case are evaluated under a situational framework, including close attention to the worker's vulnerabilities, then the evaluator can see that the workers were undocumented, they were also homeless before coming into the employ of the employer, and so that demonstrates that the employer was clearly taking advantage of these worker vulnerabilities to keep the worker in exploitive labor conditions. So under this situational framework, then, it expands the category of cases that might give rise to a forced labor case. And if power inequality is then the hallmark of forced labor in the modern arena, where overt and objectively egregious threats are oftentimes absent, then this begs another question, which brings me to my current project. Given the vulnerability of undocumented immigrants in the workplace due to the undocumented status, and the constant implicit threat of deportation, doesn't this point to an inherent power inequality between the workers and those that employ them? And does then that not make the undocumented workplace inherently coercive? So in other words, beyond trafficking, how pervasive is coercion in the undocumented workplace? So just by way of analogy, traditional Marxists, for example, consider capitalist employment relationships as inherently coercive. And though workers in a capitalist economy are not directly forced to work by their employers, Marxists contend that the general background condition of economic relations, the dull compulsion of economic relations, quote, coerces workers to submit to exploitive employment relationships. So in this way, coercion can be thought of as structural and indirect, giving the appearance of voluntariness, but in fact undermining the worker's freedom. And so as applied to then the immigrant workplace or the undocumented workplace, a theory of structural coercion would place great emphasis on the general coerciveness of immigration restrictions. A structural coercion analysis would eliminate consideration of the employer's conduct and focus instead on whether the structure of immigration laws coerce immigrant workers into accepting exploitive work relationships. For example, unlawful presence, we know, can be perceived as coercing undocumented immigrants into compliance with substandard working conditions. It's a ground of removability. Unlawful presence sustains a climate of fear, silencing immigrants and keeping them from speaking out against exploitive labor conditions. Similarly, as Jennifer spoke about, IRCA illuminates some of these problems under a structural coercion framework. Even if employers do not explicitly threaten workers with deportation, there's this implicit threat that if workers do not comply with exploitive working conditions, then they could expose themselves to deportation. So then, if that's the case, if immigration restrictions do cultivate a coercive, undocumented workplace, then we as advocates have to think of a way to remedy it. However, that kind of coercion, structural coercion, is not direct, specific, or identifiable, and therefore there is no immediate legal remedy. Furthermore, by virtue of the laws that reinforce the illegality of undocumented immigrants, they're placed in an impossibly vulnerable position. Without bargaining power, there's no opportunity to change workplace conditions, and even if the labor rights in theory are available to these workers, they can't exercise them. So the only solution then is system-wide reform. I believe legalization is the only solution to remedy the inherently coercive workplace. And to move toward this goal, this particular project begins with the premise that the 13th Amendment and related Commerce-enacted workplace rights statutes are intended to protect workers from coercion. And this idea of freedom from coercion is an essential principle of free labor rights. And just as a side note, that idea comes from a contested labor history. After the 13th Amendment's enactment, the idea that animated free labor was actually a freedom of contract idea. So it was called free labor ideology, but it really stood for freedom of contract. That individuals, an employer and employee, can engage in a free labor contract even if those working conditions were unconscionable. That was later influenced or impacted by a freedom from coercion type of analysis by labor advocates who saw freedom of contract as moving into a form of wage slavery. And so labor advocates informs labor history by adopting this freedom from coercion idea of the workplace rather than freedom of contract. So I'd like to argue that the undocumented workplace is also a highly contested area of labor rights, and that this tension between freedom of contract and freedom of labor, or freedom from coercion, still persists in the undocumented workplace. And that is largely driven by this idea that undocumented workers, because of their illegality, they're perceived to be in a collusive relationship with their employers. They freely comply, this idea that they freely comply with substandard working conditions and are voluntarily present in violation of the law. So the notion that these illegal workers willingly accept their exploitation fuels the law's continued preference of immigration enforcement over labor rights. And so as I move forward in this project, I have to answer several crucial questions to get to that latter point that I just made. Firstly, what is the scope of coercion in the undocumented workplace? What are then the implications for a free labor theory? And in utilizing this lens of coercion in the undocumented workplace, does it indeed demand the law's intervention and possibly a movement towards legalization for undocumented workers?
Well, I'm going to start, like everybody else, by thanking Irvine and Stephen Lee. But I wanted to point out that when I first walked into this classroom, I don't know if the Irvine people still realize this, but this classroom has that new car smell. And I got the feeling when I walked into this, somebody was letting me test drive the new Porsche. That's what I say, it's a pleasure to be part of pressing the pedal to the metal. And I hope I can steer myself enough through this on this presentation. So I want to talk about the Iberico system. And going after Kathleen gives me the opportunity to say, maybe the only one I'll ever have to say, right, that bad traffic is not the only barrier to getting to work. This is really still an area that I'm coming back to after a long time of writing about the criminalization of immigration law. But when I was at the Justice Department, I worked with employment discrimination laws and with immigrants. And so where it relates, I think, is to my interest in seeing the way that immigration law enforcement has affected other areas of the law, right? And that would be, right here, that would be work. So what I want to lay out is two ways I think that this country has framed thinking about work and regulating access to work. And those are the immigration law framework and the employment law framework. And so apologies to people who actually know about employment law. I'll leave those two out in a somewhat simplistic way. So the immigration law approach to work and to access to work, but particularly to work, I think is twofold. So immigration law attempts to require work, and then it also denies access to work. So if you think about it this way, it requires people to work, but the law, the legal structure does, in all of the ways that Kathleen has pointed out today, and including for other work. But as well, in the forced migration of slaves into the country, in indentured servitude for European immigrants, and in another way that I'll point out in a second. And in the denial of access to work, of course, we started out with the alien contract labor laws, sort of the Asian exclusion laws of the 19th century, which basically said that you couldn't come into the country if you had a contract to work. Today, right, unlawfully present means that you are unlawful. It's unlawful for you to work. But we also, in immigration law, condition entry on an offer of employment and continued satisfactory performance of that job. So, for example, the H-1B visa has a term of years, but it also terminates if the employer terminates your employment. So the role of government in immigration law is very, very visible. And in the national interest, the government can basically trump an employer's decision about who to hire, if that choice implicates entry in immigration, basically. So also, if you look at at which non-citizens the government grants authorization to work, unlimited authorization to work, we're looking basically at asylees and permanent residents. Work authorization is what we call in the Justice Department inherent in that status. So we're going to talk about the other way of framing access to the workplace. Right? There's a world outside of the picture that I've drawn of ultimate government control over who may work and who may not, and that's what I'm calling the employment law framework. So when I teach employment discrimination law, I spend about 15 seconds explaining that, talking about how the at-will employment doctrine allows employers to fire employees for any reason or for no reason at all. Right? And the courts have characterized employment discrimination as basically an exception to this at-will doctrine. So in that picture, it's the employer that's forefronted there. And careful, I'm getting a little bit simplistic, but employment law maybe is dedicated to how the law structures that employer-employee relationship. So the government in that picture is pretty much absent from the formation of that relationship. And in fact, sometimes the way I teach it in employment discrimination law, the government's often the good guy from the employee's perspective. It's the Department of Justice and the EEOC riding to the rescue and tearing down barriers to discrimination. The problem is when they either don't do it or they do it wrong. So, and right by those barriers, we're talking about discrimination in employment. So the question of whether the government has granted permission to access the workplace of the employee, well, that kind of gets relegated in my course to my coverage of national origin and alienage discrimination. And that's been troubling me long enough, so I had to come back and do this project. So outside of immigration law, right, the baseline expectation is that it's the employer who controls access to employment, right, to the workplace, to the status of being an employee. And we accept, for the most part, some level of coercion by the employer about what will work at, where, when. But people tend to see the government as having very little say about that. So what happens when this comparatively coercive government-centered framework of immigration law meets up with the comparatively employer-centered vision of work as relatively free from the government say over employee access to work? Well, see, that's where I think the employer sanctions laws and the E-Verify system come in. So let me just, Catherine's given me a great introduction to that. I just want to lay out a few more details about both. The Immigration Reform and Control Act was passed in 1986, and it prohibited employers from knowingly hiring undocumented immigrants and people who were not authorized to work. And it also required employers to check, ask employees for documents that showed employment eligibility and identity. E-Verify is basically a way of, it's sort of an alternative to the I-9 form. It's a way of checking the work authorization of new hires electronically. So the employer basically inputs information from the documents that you present into this computer database, and that computer database then goes and checks that information against the Social Security Administration's database and against DHS's Department of Homeland Security database. So there's been a number of critiques of the E-Verify system, a lot of them, and I think they can basically be summarized in two ways. One is the question of whether or not the system works as it's intended to. And the other one has to do with misuse. So in terms of the question of whether or not it works as intended, there's really two categories of complaints there. One is that it might be over-inclusive, right? So it's confirming as work authorized too many people who don't have work authorization. And there are estimates that it confirms as work authorized about 54% of the undocumented population. That's the Migration Policy Institute's latest figure. The other one is that it's under-inclusive, that there are database errors or user errors that are failing to confirm as work authorized people who actually do have work authorization, citizens, and work authorized non-citizens. The other one has to do with discrimination, right? That there's a disparate impact on either foreign employees or people who have what the users, the database enterer, I think perceives as foreign-seeming names that they find hard to spell, name order errors, marriage-related name changes, et cetera, and then others. The second one has to do with misuse of the system. And I think one way of thinking about this is there's two possible categories, actually three, but I'll start with two possible categories of actors who could misuse this system that we're kind of seeing coming up right now. One is employers, of course, and Jennifer has done a much better job than I ever could talking about how the employer sanctions laws can allow employers to misuse employer sanctions to harm labor organizing and undermine other sort of employment protections for workers. And Stephen Lee's article, Private Immigration Screening in the Workplace, which you should all go home and read after this conference.
Thanks for the plug, Juliet.
So he explains this is a problem of mission conflict. right? That immigration agencies and employers inherently have different missions. And that when you task employers with an immigration enforcement mission, right, they may use their immigration powers basically to support their own mission. Okay. So E-Verify enters this picture by basically giving the employer more information about the employee's immigration status. And then tells them to fulfill that immigration enforcement mission by firing non-confirmed employees. But it doesn't force them to. Like that's not what a computer really can do. So in other words, the E-Verify gives the employer a more accurate way to make that choice. They can either follow the immigration mission or use the information, the more accurate information, to ensure a more compliant, less costly workforce. Okay, so there's employers. I just want to talk about states, because what we're seeing is a rapidly growing trend in state laws that require employer use of E-Verify. So the first issue, the most central sort of, I think, the issue that I think people talk about most is preemption, right? The simple idea that this is really about the relationship between the state and the federal government, right? And who gets to enforce immigration law. And I think that's the issue the Supreme Court thinks it's deciding in Whiting. I'm not sure that's true, but I'll leave that at least for the moment. What's also happening, though, is that what the states are really doing is claiming a greater role in the creation of the employment relationship, in access to work, and in decisions about who the employer hires or retains. So it's states are using employment as a means of enforcing other enforcement goals. Okay, so one question is whether that's a problem in the first place, because after all, the states are using this, right, to increase the enforcement of the immigration laws. And so unless you're an immigrant, why is that a big deal? Well, one problem might be what they might actually be doing is trying to change the demographics of the state population. But others have talked about that in other parts. Okay, so there's another problem that I want to raise. And this is the part of my project where I start to feel like Shaggy in Scooby-Doo, right? Where he says, "Oh, I have a bad feeling about this movie." And Scooby responds with, "Bravo." But they don't know why they have that bad feeling until they get clobbered. So let me try to discern two of the ghosts. So one has to do with employment and law enforcement. So put it this way, E-Verify together with IRCA, with the employer sanctions, acts as a portal for governments, right, federal and state, to have a presence in the inception of the employment relationship. So let's put that together with the greater powers that it gives to employers to choose whether to use E-Verify results only for immigration enforcement, but also for their own purposes. And so the upshot is if you put those together, E-Verify gives employers, the federal government and the states, a greater role, more power to operate in the realm of access to employment. And the problem is that that's, I think, a net loss of freedom for employees, like all employees, not just immigrants, but citizens as well. Now, on its face, you could say that's really only going to affect a small percentage of employees, because what we know right now is about 2.6% of everyone who gets checked through the E-Verify system, you get even a tentative non-confirmation. Like that's sort of the first, I think that's what it says, go check with the government to make sure your documents are okay before we issue a final non-confirmation saying that you can't work. But what's important is that it normalizes the role of government in using access to the workplace as a legitimate location for law enforcement. And I think outside of immigration law, we see one of our freedoms as citizens and permanent residents and other, as residents of the United States, that's one of our freedoms. Whether and where we work is something that's central to our social structure, to our democratic society. And we need to ask the employer for permission to work at any particular workplace, or to create our own work, but not the government. I think that's the way people generally tend to perceive that access to the workplace. Right? And the government, for example, doesn't issue employment authorization cards to its citizenry. But I think that actually changed in 1986. I think the Immigration Reform and Control Act transformed relatively private decision-making about access to the workplace into a regime in which the government is authorizing employees to work, including citizens. Right? So the Immigration Reform and Control Act and E-Verify makes the access to work of every person contingent on the permission of the U.S. government to be employed. And E-Verify makes the decision of every employer to hire any employee contingent on the permission of the U.S. government to employ that individual. But my intuition is that up till now, very few employees think about it that way. I think E-Verify is the Cheshire Cat conversation. Right? E-Verify is going to make IRCA's transformation visible to every employee to some extent. Right? It goes beyond IRCA in making that government role visible. So as the computer is checking the information, E-Verify is going to virtually bring the Department of Homeland Security into the workplace. And it makes the Department of Homeland Security an active participant in the decision about whether the employee keeps her job. So why should we care? Let me give you a pragmatic and a philosophical reason. David Cole has often talked about how immigration law is often the wedge for government curtailment of mainstream liberties. This is watch immigration law to see what's going to happen to citizens next. And DHS's law enforcement role here with E-Verify is about immigration law enforcement. But if you think about it, the Department of Homeland Security's mission is broader than that. Right? It's about national security. And what E-Verify gives the Department of Homeland Security is information about every U.S. worker who passes through the E-Verify system. And I wonder whether at some point it's going to be tempting to use that information for other purposes. And here's a philosophical one. Like work is, it's central in our society. Right? We use it to generate our income to sustain ourselves and our families, to support pastimes, obtain goods. Work has social and personal meaning. Cindy Estlund has talked about work as one of the most racially integrated aspects of many of our lives. And it can be a central place, she says, where democratic integration occurs. So I'd like to see us be very careful about how we let the government use that delicate moment where work begins.
Well, thank you, three fabulous panelists for terrific papers. In the interest of time, I'm simply just going to pose one question to each panelist. I have a sneaking suspicion that you might want to turn it around for a conversation of the group since we have all these great minds in the room, but I'll let you decide what you want to do with that. First, for Jennifer, I wanted to maybe think about focusing on the very last question you asked about managing the future flow of immigration policy. I know this is an issue as to which Mike Wishney has given a lot of thought because it really is core, I think, as both labor policy in the United States going forward, and to maybe get you to hazard some ideas on the hard questions and trade-offs that you think advocates and scholars ought to be thinking about as we look forward. For Kathleen, I was thinking both with your hat as an advocate, an activist, and as a scholar, the push to define coercion more broadly has lots of appeal if you think of the Trafficking Victims Protection Act. This is a rights protective statute in an area where there has been so little rights protective legislative or case law development over the last couple of decades. And so I can see the temptation to want to define coercion more broadly so that the TVPA and, for example, the visas that you can get under it are more broadly available. But I'm wondering whether there is a risk in defining it sufficiently broadly that everybody in theory becomes coerced, and thus there is no protection for workers more generally, at least if we exist in a world in which coercion and exploitation of low-wage workers is maybe a feature of our legal culture and our economy going forward. Is there a possible unintended consequence? I don't know. I'm not arguing. I'm kind of raising questions. And finally, for Juliet, I'm wondering whether strategically there would be ways to mobilize the general anti-regulatory stance of employers and the business community against this form of intrusive regulation. In theory, employer sanctions could have done that. It could have gotten employers to kind of rise up and say, look, I don't like OSHA, I don't like employer sanctions, I don't like the EEOC, I don't like any of this regulation about telling me about guardrails or ladders or record keeping about which racial minorities are represented in my workforce and which percentages. And I don't like E-Verify, and whether strategically there would be a way to think about strong libertarian streets in Arizona, what it would take to get employers to say, you can't take my business license away just because I wanted to hire this group of workers. Are there possible sort of conceptual coalitions that could be formed in academic work and then on the ground, political coalitions that could be formed in this area if we reconceptualize E-Verify as being, the absolute worst version of the IRS and the Occupational Safety and Health Administration all rolled into one.
Is this on?
Yeah.
Now it's on. So to respond to that question, I think as soon as I sat down, I realized as I had thought this whole thing out, what I didn't put in at the end as one of the things that we don't believe is a good idea is, of course, guesswork, right? Guesswork programs was the answer in comprehensive immigration reform to the what do we do about the future flow question. But for many of the same reasons that many of us oppose employer sanctions, we also think that guesswork programs are gold mines for exploitation from the workers, well, maybe from the employer's point of view, but harmful to the worker. And then there's this whole debate about is there any such thing as a good guest worker program? And I think to the extent, some people won't buy into any guest worker program, and some people feel like if you have a guest worker program that has complete mobility for the worker, completely equal rights, and a path to citizenship, that's a possibility, right? But I think the hardest questions on this one, I think there's two kinds of ways to go about the answers. One is large and conceptual. How could we reconfigure immigration law so that it's consistent with decent work for all? And the other, and I think harder, is really hardcore and numerical, right? You can come up with, and I face this particularly in having proposed a system that I think works better for decent work for all. And the question is, how many? You create the ideal program, and how many people are you going to let in under that program? And so I think for those of us who prefer to work with the beauty of models, that's really the challenge, is to figure out what size once you figure out what looks fair, how many people get to come in under that? And we're very, very reluctant to do that. And our reluctance to do that means that our beautiful models aren't entering into the national debate.
It's a really good question. Oh, I'm sorry. Melissa's still over here. A really good question, Catherine. And I've been challenged with that question previously, and certainly there could be unintended consequences with expanding a definition of coercion so broadly, like you said, that all workplaces that are susceptible to violating the Trafficking Victims Protection Act, because all workplaces to some extent are coercive in power. There's inherent power, like as I mentioned with the Marxist theory, there's inherent power differentials between employer and employee. So this particular project is informed by a coercion analysis as developed under the TVPA, but moves beyond the TVPA. So under the TVPA, there has to be a specific dyadic relationship between the employer and employee. There does have to be some evidence as to an employer's intentional taking advantage of the worker, and but that's evaluated according to all the facts and surrounding circumstances of the case. And what the TVPA does accomplish with respect to a coercion definition is this situational analysis where the vulnerable conditions of the worker, the background conditions of the worker, are actually prioritized in the evaluation. So, so what I hope to do is take that piece of it to inform a structural coercion analysis in the undocumented workplace. Because if we look at trafficking victims and we see that for the most part they are rendered vulnerable because of a precarious or undocumented status, then that better informs how immigration restrictions more generally might structurally coerce the workers in the undocumented workplace. And so that can't be fixed by the TVPA, and I don't think it should. What I do think is that because of potentially this inherent coercivity of the undocumented workplace, that it should be, I know that calls to legislative reform in this area have not worked, and they probably aren't ever going to work, but I hope that the salient significance of a free labor lens, as derived from the 13th Amendment, might be another call to the legislature to promote legalization efforts.
So Catherine, your questions, can you hear me? So your question's a really interesting one, and to some extent I think the question of whether there's some strategic aspects to this. And I think with Chamber of Commerce versus Whiting, that's to some extent that's what the employers are doing, right? They're kind of standing up and saying, hey, this is we can't take this kind of role in our workplace. And as I was sort of writing this article, I was thinking about that, but also thinking about whether there are other groups to bring in, and thinking in particular about whether Morris sort of laying out the citizen proxy, whether there are arguments that you can make to protect immigrants that draw on citizens as proxies for those rights. And so I'm gonna be so Peroshi and Letty are the optimist and the pessimist in this trope. I'm gonna try to channel both of them. Right, so here goes. I think the citizen proxy argument would be one that tries to channel the little libertarian in all of us, right? That the one that says, well, I don't want the government to be messing around with my right to work. We don't necessarily have one. That's part of the problem. But maybe that's one way. That's the way that we kind of think about it. And so that concern might activate citizens and others who have authorization to work, right, enough to kind of mobilize some feeling and arguments that pertain to Iberico in ways that aren't, those arguments are being made right now. Okay, so here's the pessimist in me. I have the feeling that when the employer puts U.S. citizens, for example, information into the E-Verify system, right, and the computer comes back and gives a little beep or whatever it does and says, you're work authorized. And welcome to remaining in employment. This is for new hires. I think there's some proportion of the citizens who are going to say, my membership has just been confirmed. Right, I'm in, and this system has just confirmed my membership. And so, and that makes me feel good, and so I think the system is great. So it's not really going to activate the little libertarian inside of us all. So I think that's one problem with the citizen proxy argument, is that the citizens might actually not see that there actually is a proxy, and people might not be making those arguments. What that gets us back to is the panel before, right? The idea that we can repudiate the other in order to confirm our own membership, and I think that's what E-Verify might allow us to do. There is an argument that I've been looking at, and it comes from some of the national security literature about how we conceive of sort of government intrusions that aren't necessarily intrusions that say you can't do something, but they're more like immunities. They curtail our freedom, our way of understanding how we should be treated in the workplace. And I need to do a lot more work in sort of looking at that, but that might be more productive
David.
So I have a clarification and a question. The clarification is that Kathleen credited me and Jennifer with the title incoercible, but I should also add that my colleague Mario Barnes was involved in the conversation. And like most of my contributions to the school, I was just riding in on the coattails of Jennifer and Mario's expertise and wisdom. So I just didn't want him to lose out on credit for that. But the question is this. So I'm really interested in not just the enforcement of laws, but whether and to what extent the identity of the enforcer can affect outcomes and the public's understanding of what may or may not be an appropriate or attractive outcome. And a few of us have been really looking at whether and to what extent empowering or tinkering with the responsibility of the Labor Department, the EOC, state labor agencies, whether that can affect how we think about labor rights, specifically how the public does. Here I'm thinking of Leticia Salcedo, Shannon Gleason's been doing some of this work, and my most recent work is focused on that. And the question I have for you all is, how would you feel if you tweaked it a little bit so that the Department of Labor would take a more proactive role? Is there a place, in other words, for the public enforcement of the labor laws? Jennifer, your work, we talked about organizing and the role that labor organizations can play, but that's really a channel of private enforcement. So I just would like to hear your thoughts on that. And Juliet, I know that Irvine currently is regulated by DHS, but how would you feel if labor was playing a more regular role in this? And I guess the same goes to Kathleen as well.
Get stuck in this order, we're going to just keep running. If I understand you right, you're talking about a piece I just published with a political science colleague arguing that the Department of Labor, in its enforcement of minimum wage, would do well to create a formal role for workers' organizations, including unions and workers' centers, and pointing out a couple situations where this is already happening on the state level, that it's not as legally infeasible as some have argued, and that in fact it works quite well, which is just, as Stephen said, one idea for bringing more power and more effective strategies to workplace enforcement for all workers, but particularly for immigrant-heavy workplaces.
I think as a theoretical matter, Department of Labor is really appealing because their charge is to enforce Fair Labor Standards Act, and their investigators, their due diligence involves interviewing both sides, and they don't necessarily side with one of the sides, but they look for workplace violations and seek to rectify them. I think that there's a field of scholarship that deals with public versus private enforcement, and public enforcement has, the reality of it is that public enforcement has been, challenged with scarce resources, and I think that is a problem. And because the public enforcement agency, even the Department of Labor, while they're enforcing really good law, then from an activist sort of individual rights perspective, the enforcement of the law might supersede the representation of the workers' interests. And so, just from my own experience, in terms of representing the worker individually versus getting the Department of Labor involved, there was sometimes a tension between the individual interests of the worker in pursuing their legal case versus the interests of the Department of Labor to overtake the investigation of workplace violations.
Oh, thanks for giving me a minute to think about Stephen's question. So let me do the pros and cons, and maybe a pro. So I think with the Department of Labor, one of the nice things about putting the Department of Labor in charge of the E-Verify system might be that the labor would have a greater tendency to focus on employer misuse. Right, so situations where the employers are supposed to be confined by a memorandum of agreement with the government that says, I'm only going to use this system to verify new hires, not established employees, and not to pre-screen employees. But there's no way that there's a monitoring and compliance division that's been in place since 2007, but I don't think it's doing a lot of work in figuring out how much employer misuse of the system there is. There's a little bit of it, and they're trying to work on some sort of automatic ways of looking into some of that. But I think what they're supposed to be doing is then sending that information to ICE And I don't think that that's not really ICE's appropriate mission. So I think the Department of Labor would do a better job of that. The problem is, don't you end up at that point, however, if the Department of Labor is the agency with mission conflict within the agency, because they're supposed to be protecting the rights of employees and at the same time, right, having an immigration enforcement mission. And I don't know how they would resolve that. And drawing on your work, right, I think they would end up having to make a choice between the two of them. And maybe that would be the right choice. But maybe here's another pro of giving it to the Department of Labor. They might do a better job of actually taking into account all of the costs to employees and to the labor force of the E-Verify and the employer sanction system. It might be more capable, perhaps, of coming back to Congress and saying, "Wow, this is right, there's some real problems here," and there's an idea of how to fix it. Yes.
I'm an immigration lawyer of about 30 years, and my experience with, I have a comment on your earlier point about the libertarian element, but before we leave that, the Department of Labor, in my experience, should first be evaluated for its performance under immigration administration, and if that were done, they would be found, as would all the other agencies, to be woefully inadequate in their performance. I mean, if we concern ourselves with the rights of labor, American workers in particular, the Department of Labor, in order to allow for a test of the labor market, requires American employers to create an artificial test that is a hoax on applicants for employment who are U.S. citizens. And so, and they have the resources to determine from their own statistics shortage occupations and decline to do it because they won't face the political heat. And so I would say that we tend to accept too much of the status quo when we want to throw more and more agencies into the immigration function with conflicting missions. If you wanted to fix the E-Verify system, I would suggest that the Department of Justice Office of Special Counsel would be better equipped to do that. They do have a memorandum of agreement with DHS on violations that are brought to their attention. They've been very vigorous in enforcement. And you might also want to have a private right of action that would avoid the conflict that exists in the Department of Labor's espousal of its own interests over those of workers. If there were a private right of action, given all the hungry hungry plaintiffs' employment lawyers out there, I think that would be a vigorous enforcement tool. But my point is, I'm hopeful that there will be a libertarian streak in the American people, but I didn't hear a peep when U.S. passport information was fed into E-Verify, which was never intended for that purpose, and there was no forewarning to a U.S. citizen passport applicant that their personal data was going to go into a government database for employment verification purposes. I also am surprised that there has only been pushback on Real ID from the states for the costs, but not from a libertarian perspective, that this is another encroachment on citizen rights. So I would love to see American workers recognize that to truly have an enforceable immigration system, they have to accept some burdens, and then maybe they would be more reasonable in what they expect. But I don't know if you want to comment on any of that, but I'm not sure there are reasons for optimism. I'd like to be, but I'm not sure.
So I'm not sure either, but I'm trying to find them. And so in thinking about, so you kind of raised two really interesting points. Think about who's the best protector of employee interests. So I used to work for the Office of Special Counsel, and that's been something that they had thought about. It was what kind of role they should be playing in E-Verify. The problem is that their expertise is in discrimination, and what I'm talking about has something to do with discrimination. Right? There are a lot of aspects of discrimination that are implicated by this, but there are also other sort of non-discrimination related aspects of employer misuse that go well outside of their expertise. So without expanding the role of the Office of Special Counsel tremendously, as well as the number of staff, because I think we were 12 attorneys for the whole nation at some point in time. Then I think that's a partial resolution, but not one that really gets us into the larger issues.
So document abuse has nothing to do with discrimination necessarily. It's an expertise that they developed, and they could certainly develop e-verify misuse as another expertise.
Yeah, I think that's possible. And then the other question of a private right of action, that's another possibility, and I think it's a really good place to start. The offices within the anti-discrimination divisions of IRCA have a private right of action, and it's been tremendously underutilized. And I think that's probably because the statutes too, and just the forms of discrimination that the statute actually covers are almost useless. I shouldn't say that. It's not true. Because I don't mean to disparage my old office that way, because they've done a tremendous amount of work. But I think the kind of work that they've done that's really helped with this sort of issue is more policy related, and then more sort of working with other governments to make sure that other agencies to make sure that that some of these civil rights issues get addressed. And I will stop there. We can have a further conversation about some of the other pieces.
See, Mike had a question, you had a question. Why don't we go with you and then Mike?
Okay. Jennifer, I just wanted to add a fifth conundrum to your list.
As if we don't have
enough. Longer than four. First, I want to say, as a demographer, I appreciate your nuanced reading into economic analysis about the pros and cons of labor. I think I'm a little bit more cynical about if you were to take a clearer read of that data, it actually poses additional questions, especially if we compare the impacts at the state, federal level, and where it's at this point. But that aside, I wondered, kind of going off of this logic of the economic incentive of undocumented labor, but also even high-skilled labor, whether it poses an additional problem not only for us in this room, but also the advocates that you and the rest of some of us work with, which is, are we boxing ourselves in to kind of focusing on an economic incentive on the one hand, but then how do we manage that with this other work that we do in terms of encouraging paths to mobility? So once these workers, if we achieve our other goal, no longer pose that economic incentive in this certain framework, we just shot ourselves in the foot in terms of arguing on the other hand. And so it's kind of another conundrum that I deal with in terms of how to harmonize social justice or economic justice work with the other claims of that Tron looks at and some of the other stuff we talked about.
Thank you. No, I just took that as a helpful comment.
Okay, good. Mike?
This is so great, and for me particularly, just because to some people, I feel like I've been saying the same thing for a while. So like fresh ideas is so excellent. So thank you guys for all the contributions. So I kind of have a quick question each down the line. Kathleen, I love the suggestion that being undocumented is 13th Amendment, which I take is somewhat implicit in what you're saying. But I wonder more narrowly with your views on the guest worker program, which has come up. Those peonage cases you mentioned say at bottom that you can't go to jail for quitting your job. But guest workers can go to jail for quitting their job. They can go to immigration jail because their status is immediately forfeit upon quitting work or being fired. So I wonder whether there's not a 13th Amendment problem, as you can see through labor, with our existing guest worker programs. Juliet, I'm wondering, there's no small business exemption to IRCA. But E-Verify has more space to operate. It's the only workplace law I'm aware of that does not have a small business exemption. And I was struck by your final beautiful note about the delicate moment of entering work. And I was thinking, I'm not sure someone who starts at Walmart would put it quite that way. I think you had a conception of more of a mom and pop shop, which in every other workplace law, environmental law, many and regulatory schemes and others and exemptions, but not whether there shouldn't be an exemption in E-Verify is even larger. Maybe there should be an IRCA that would require statutory change, but not E-Verify. I'm kind of curious from an anti-regulatory perspective your thought on small business exemptions to E-Verify. And then to Jennifer, sort of the heart of this. So I so appreciate the project of trying to figure out how to get past the rhetorical conflict issues of summarized with Maxine Waters, that exchange, which I can see still resonates 10 years later. So
5, but it'll resonate for another 15.
But I'm kind of, there's the politics of it and how to get it done, and there's the kind of analytic conception, what kind of a system might we sketch out in an ideal world. But I wonder if there isn't a little space in between for a public policy discussion. It's not just the politics. You propose a reduction in employer sanctions, and someone says, well, where's the new enforcement going to come from? It's, you know, a political matter. If you reduce some enforcement, you've got to spike it somewhere else. But just as a pure public policy matter, so 25 years ago, Congress said we have two goals. We're going to deter illegal immigration and we're going to protect U.S. workers. And for 100 years, we didn't have sanctions as means to achieve those goals. But our federal immigration laws had those goals too, I think. And it's now sort of accepted that sanctions must further those goals. But I think many of us could embrace those goals and say, well, as just a pure public policy matter, we're not sure this is getting us towards either of those, and whether there isn't space between the politics and the pure analysis to say, this is just one more thing we've tried towards long-standing goals, and it hasn't worked out. It's had counterproductive effects in many ways, but it hasn't achieved the goal. So can we not just say, we actually agree? You started by saying, sometimes you doubt the other side's commitment to protecting U.S. workers, right? And our commitment to deterring illegal immigration is sometimes doubted. But isn't there a way to actually genuinely and sincerely embrace both of those goals as important goals, and then say, well, let's just figure out better ways than this to try to go there? Does that create any more space in your discussion?
Okay, so I'll quickly respond. Thanks, Mike, for the good question. And I absolutely agree that that guest worker programs, that you can create a more direct relationship with the 13th Amendment violation. And Maria Ontiveros has done quite a bit of work around that. And so I totally agree. And you know, maybe I've taken I'm not good with cliches, but a bigger bite than I can chew or something. But yeah. So I mean, it's possible that guest workers will be a part of this larger project, but ultimately, my goal is to at least propose a new way of looking at legalization for undocumented workers more generally, and which is why I chose undocumented workers more generally.
So I'm all for small business exemption to E-Verify. And here's some support for that. Right? The E-Verify has been a quote-unquote voluntary project, right? So that employers get to volunteer to be involved, to sign up for E-Verify. It's not voluntary for employees, right? But because what the employer is saying is we're going to signing up for E-Verify, and we're going to run all of our new hires, whether they like it or not, right, through the E-Verify system. So, and what's happened is most of the E-Verify employers have been large corporations, which, because of consolidation, it's easier to train human resources, and they tend to have more expertise in the employment laws. So one of the problems with expanding E-Verify nationwide is we start to get to smaller employers, ones that don't have human resources departments. And so we're going to end up with more errors, possibly more different forms of discrimination. And so as well, once you move beyond the volunteers, the population of voluntary employers, what we've seen in Arizona is that employers get less happy with the E-Verify system than they've reported so far. And it looks like they're also getting less compliant with the limitations that E-Verify places on them how to use this. So, now the only thing is that I think by exempting small businesses, depending on how small you get, we end up exempting actually a pretty large population of employees. And, so and some people might have a problem with that. But that's, but I think it's worth it. I think E-Verify will have enough, but there's too many costs to expand it.
So I think there's one possibility, and I didn't fully understand your question, so we can talk later. But if I think that what you're suggesting is what we've been trying to do, right? To say, the protecting worker, we have the protecting worker mission and deterring illegality mission, and we got lots of ideas on protecting workers, and let's look more closely at them. They're also going to deter illegality, right? I think that's been our default position, and then when other possibilities are brought up to deter illegality, employer sanctions, raids, silent raids, whatever, we don't like any of them. And I don't mean that as a critique. I mean it is true. I don't like any of them. And so but I think that because our only answer is really focus on workplace standards. Well, not because. Our only answer is really focus on workplace standards, and therefore, we don't want to look too closely at that, because I can't bring to mind right now any other answers in terms of what we're offering for the deter illegality side, and yet I have some doubts about whether we really think enforcing workplace standards is going to deter illegality. We think it's going to protect workers, and that's what I care the most about, but it has started to feel disingenuous to me to offer that as our only, I think it's part of the package, but our only deter illegality proposal.
So we have elapsed our time, unfortunately, because I could go on for hours more, but there's also a bunch of sandwiches outside from Lee's Sandwiches. What time do you want to reconvene, Stephen?
1-ish.